So if you want to keep playing that the United States Supreme Court is the highest court of the government instead of the land, it's not the highest court of the land, it's the highest court of the United States government. The highest court of the land, and if you Google the word land, it says people, the people of the land. The highest court of the land of the people is the common law court of record. That's why I said, what's the characteristic of a federal court? Section 344, Chorus Juris, Volume 25. It says it right there. It said federal district courts are courts of record. End of the story. Why would I want to go into any other court other than a federal district court? And it's all low.
I don't know. They've changed they claim now that the United States and the United States of America are the same.
Well, that's what I'm saying is they changed it. You didn't change it. Like this is just says, well, we don't believe there's a common law courts anymore. We don't do common law courts anymore. It's like, so when did we become me? We is what? Yeah. The judges and everybody here? That's fine. We is not me. When did the common law court outlaw it? Can you show me? Of course, like I said, you see that in traffic court all the time. That they'll say something like, well, is there a reason why I can't establish a case in a common law court of record and move the state prosecutor or the county prosecutor who's trying to prosecute a false charge that I went of a crime that I drove too fast? Is there a reason why I can't drag him into a common law court of record and bring him into my case?
Well, they're trying to use municipal color of law.
Well, what they'll say is, well, we don't do the common law anymore. It's like, yeah, can you show me where the common law has been outlawed? Can you show me where it says somewhere that we do? Show me where it says that, because I hear you saying that we don't do common law jury trials anymore. Can you show me where it's written down? It's like, okay, and it's like, well, there's that code. It's like, well, that's a code. That's not a law. Where is it outlawed? When did you throw away my Constitution? Because the 7th Amendment says if this is worth more than $20, I have the right to move a common law court of record, and once the jury comes down with a verdict, it can't be heard or retried by any other court in this land. Because that's what I say to people. Oh, that's a great thing to say to the judge. You say that to the judge. If the judge starts going off on you about stuff, say, Judge, if I lose, can I appeal this? And the judge says, yes, you can appeal it. Well, then I'm not on the court of record. Because in the common law court of record, under the 7th Amendment, says once it's been tried by a jury in the common law court of record, it cannot be heard or retried by any other court in this land. So obviously, Judge, I'm in the wrong court. Because I want to.
What Constitution are you using? I mean, you're not a party to the Constitution.
That's right.
United States.
You're not a party to the Constitution, but the state and the federal government are. And the state and the federal government says that this is a contract between the governments, that we will not interfere with the rights of man. And if anybody interferes with the rights of man, the man has the right to come back and sue the government. The Constitution is just to protect our rights. It's just to make sure that the government doesn't interfere with our rights. That's all. We're not a party to it. I don't want to be a party to it. Because once you sign a contract, you relinquish certain rights to obtain privileges. So I don't want a privilege from anybody. My dad taught me this when I was a little kid. If you sign your name more than once and twice, you should be an honest man. It's an old saying. An honest man should be able to go through his entire life without ever signing his name. Because once you sign your name, you're relinquishing certain rights, and you're obligated to some other man. You're obligating yourself to somebody else. You're becoming like their slave. So everybody
okay, if you want to do something and you want to rescind all your signatures, you need to have, do you do it non-pro-tunc to birth?
Yeah.
To
You just don't want to access you. Like I said, if the IRS is coming after you and they try to say, well, are you a U.S. citizen, what does that have to do with me getting a letter in the mailbox? And I'm telling you, it's causing me stress. What does that have to do with me having a driver's license? What does that have to do with me having a Social Security number? What does that have to do with anything? Because no man is going to ever stand across you in a court of record. It's always going to be an attorney. So the attorney's not allowed to speak in the common law court of record. I told you what my sister did when an attorney tried to speak. Right. And the judge told the attorney the rules. You know the rules. An attorney's not allowed to speak unless they have first-hand knowledge or witness something. So is that attorney going to say they have first-hand witness knowledge that you obtained a Social Security card sometime in your life? The attorney's going to be like, no. I have no idea if she's got a Social Security card or if she rescinded it or she revoked it. You guys are doing way too much paperwork. And like I said, I don't charge a dime to help anybody. So you got to be careful. All these people who are teaching you this stuff and they're charging you money, you know what? I always say, how is that relevant to the matter at hand? Where is my common law court of record? And the judge tries to talk to me and said, can I appeal whatever decision comes from this court today? He says, yes, then I'm not in a court of record, because the Seventh Amendment says that if I'm in a common law court of record, I cannot appeal this. There is no retrial and there's no rehearing by any other court in this land. I want to go into a common law court of record, and I want to go there now, and I will only answer there. I'm not going to answer about Social Security costs. I'm not answering about tax returns. I'm not answering anything. Can I appeal it if I lose? Yes. Well, then I'm not under the Seventh Amendment. You're not obeying your oath of office. Your oath of office says that you have to protect my rights if I evoke the Constitution to say that I'm a man, and if it's worth more than $20, I have the right to move this before a court of record. Where's my court of record? You took an oath, right, sir? Yeah. And that's what I always tell people all the time. This poor guy said to me, I think Tom Murphy, said he's suing a judge in, like, tax court. I said, she's not a judge. She's an administrating hearing officer. She's under the administrative capacity. It's like she works for Coca-Cola. So if you work for Coca-Cola and Coca-Cola told you to come before an administrative hearing today in Coca-Cola Board of Directors, and you try to say, well, I have the right to carry a gun. I got the Second Amendment right to carry a gun. She'll look at you. It's like, sir, this is Coca-Cola. This is an administrating hearing. I don't know what the hell you're talking about, constitutional right. You work for us, you know. So like I said, when you people are like, well, the United States citizen, well, you work for them. You're you're like an employee. So you'll start saying, well, I got this right. And you're talking to an administrating hearing officer. It's not a judge. She didn't have to take an oath of office to become a Coca-Cola hearing officer. She doesn't have to take an oath of office as she's an administrating hearing. So the easiest thing to say when any woman or any man who's wearing a black robe comes before you, say, if I lose, can I appeal this? And they said, yes. Then I must be in an administrative court. Because under the court of record, I can't appeal it. It's over. It's done. The Seventh Amendment is very simple. There's nothing, like I said, there's nothing fancy about the Seventh Amendment. It's like one sentence long. And like I said, I'm typing that right now because, like I said, it's very simple. And that the easiest way to get this all done with all these judges is just say, can I appeal the decision of the court today? And he says, yes, I'm not on common law court of record. Here you go. The Seventh Amendment. In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States other than rules of the common law. There you go. So it can't be re-examined in any court in the United States, so I don't know where they're going to retry it. It's a very simple, Seventh Amendment is simple, and the Ninth Amendment is even simpler. The Ninth Amendment just says whatever rights man has before this contract was written between the federal government and states, man still has those rights. Those rights never changed. So the Ninth Amendment is it's actually called a savings to suitor clause, and all that means is that it's an escape clause for a man who doesn't want to operate underneath that contract. So, like I said, it's the Ninth Amendment. Nobody talks about the Ninth Amendment, but the Ninth Amendment is the most powerful amendment that we have to drag everybody into a common law court of record. Because it's like, look, I had the right to drag everybody into a common law court of record before this Constitution was created. I had the right to go before a jury before the United States existed in 1776. I had this right to have a trial by jury for the last 10,000 years. Just because you guys made a new contract between the federal government and the states doesn't eliminate my rights, because it's very simple. See, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. The people always had a right to go before their community for a trial. And you go back to Hammurabi, you go back 10,000 years. You go back to cavemen. They always had a right to have other people determine whether or not they'd done wrong to each other and determine what the punishment was going to be. Way antecedent to the Constitution being enacted. So what they're trying to say, well, now we have a Constitution, now we got to do it all this way. No, we don't. The people always got the right to do it the way we've always done it. Just because you guys came up with a new Constitution, it's 1793, doesn't mean we're going to forget about the old ways, how we always did things. And they said, okay, fine. Whatever rights you had, to have whatever trials you had prior to this Constitution, you know what? You still got that right to do that trial that way. So there you go. You always throw the Ninth Amendment at them. Well, it's really the Ninth Article. But like I said, you know, that's how you pin them in there. That's how you pin judges in the seats, if you say it correctly.